In a free society, confidentiality is more than a courtesy. It is a fundamental pillar of trust. Whether in the examination room, the attorney's office, or the confessional booth, certain relationships have long been protected by a simple principle: what is said in confidence stays in confidence. This was a recognition that certain professional relationships can only properly function when insulated from surveillance and coercion. However, in modern America, these sacred trusts are being eroded by government mandates, digital intrusions, and public policy drifting away from liberty and toward control. Consider the doctor-patient relationship, once understood to be nearly inviolable. Patients shared their most intimate concerns under the assumption that their disclosures would remain private. It allowed doctors to diagnose and treat without fear that their patients would withhold critical information. But today, that trust is increasingly compromised. Government reporting mandates now require doctors to report a growing list of health information, sometimes under penalty of law. These electronic health records are often linked to databases accessible by government officials and third-party contractors. In some states, physicians are compelled to even report gun ownership if a patient expresses emotional distress. The justification for such intrusions is always the same: public safety, public health, or that vague concept promoted as the common good. The pandemic accelerated this trend. Under the guise of COVID-19 contact tracing, vaccination records, and community safety, the government gained unprecedented access to personal health data. Some doctors were even threatened with license suspension for expressing dissenting views on pandemic policy. A similar decline can be seen in the realm of legal counsel. The principle of attorney-client privilege is supposed to be ironclad, ensuring that even the guilty have the right to mount a defense without fear that their lawyer might become a witness against them. But modern government practice has taken aim at this also. Prosecutors increasingly seek to pierce attorney-client privilege in politically charged cases. When discretion is left to bureaucrats or judges with political agendas, the exception can quickly become the rule. We saw this play out in cases where government agencies raided law offices, seized privileged communications, and government lawyers were the ones to decide which documents are protected and which are not. Remember Michael Cohen? When that happens, we no longer have a legal privilege. We have a legal pretense. Clergy penitent privilege is also challenged when the state deems religious confessions to be in conflict with mandatory reporting laws. The therapist-client relationship is riddled with carve-outs and disclosure requirements. Even the financial advisor and client relationship is no longer free from surveillance, thanks to a raft of regulations requiring the flagging and reporting of suspicious transactions, an undefined term that gives bureaucrats broad license to probe. What all these trends reveal is a fundamental shift in the balance of power between the individual and the state. Confidentiality, once viewed as a protection for the individual against government overreach, is now being reframed as an obstacle to government control, while the language used to justify this shift is always dressed in noble-sounding abstractions: safety, health, transparency, security. What it actually means is that the state reserves the right to know everything about you. The cost of this transformation is the destruction of professions. A doctor who fears that an honest conversation will be monitored becomes a bureaucrat with a stethoscope. A lawyer who hesitates to give frank advice because it might be subpoenaed becomes an agent of the state, not a client advocate. A pastor who wonders whether to report a confession becomes a snitch, not a shepherd. The erosion of these trusted relationships produces patients who don't tell their doctors the full story, clients who hesitate to trust their attorneys, and parishioners who turn away from spiritual guidance altogether. What makes this trend all the more dangerous is its creeping nature. No one declared the end of confidentiality. It is being undone subtly by incremental policies, executive orders, and professional guidelines. The very people tasked with protecting confidentiality, doctors, lawyers, and clergy, are being slowly morphed into instruments of state policy. History has shown us where this leads. A government that can peer into your medical file, your legal records, your spiritual life, and your finances without resistance is not a guardian of rights, but rather a manager of lives. The birthright of liberty is therefore reduced to a permission slip. For this very reason, the founders of our nation wrote a constitution that assumes government power must be restrained. Confidentiality is one such restraint. It is not a loophole to be closed, but a firewall to be maintained. To defend it is not to protect criminals or endanger society. It is to uphold the only kind of society worth living in, one where free individuals can speak, seek counsel, and be healed without the state listening at the door.
Can you say why America is the greatest country in the world?
Freedom and freedom. So let's keep it that way.
I think that the real job that we have that confronts us is to somehow be able to sell our fellow Americans on the moral superiority of personal liberty.
I would remind you that extremism in the defense of liberty is no vice.